We're pleased to have as our guest Adam White, who is a lawyer in Washington, D.C., and who writes occasionally, but maybe sometimes more than occasionally, and certainly of more than occasional interest for the best conservative publications. The City Journal, the Wall Street Journal, the Weekly Standard. He is an Iowan, and he graduated from the University of Iowa and then from Harvard Law School, where he graduated in 2004. His topic today is Hear the People Rule, ? The Supreme Court in American Law and Politics. Adam White.
Thank you. It's an honor and pleasure to be here, not just here for this program in particular, which I admire and enjoy greatly, but also to be back at Harvard, where, as Harvey mentioned, I spent 3 very happy years first studying the law, and to which I'm always pleased to return. Harvey began with my title, so I will too. Hear the People Rule. For those of you who don't recognize it, it's actually a line from Gerald Ford's remarks upon being sworn in as president after Nixon's resignation. But perhaps of more immediate relevance, that phrase, hear the people rule, minus my question mark, is the name of 2 significant books on constitutional and popular government by 2 Harvard professors. I brought them with me. The first is a collection of essays by your late colleague Ed Banfield, author also of The Unheavenly City and The Moral Basis of Backward Society. In his introductory essay, Banfield quoted that line from Ford, and he added, in my view, the feature of that system that is analytically most interesting, that is, the one that's most useful in explaining, is the extreme fragmentation of formal authority. Many consequences follow from this fragmentation, the most obvious being perhaps the widespread participation, or some would call it interference, in the day-to-day conduct of government. And Banfield conceded that rule by the people allows no place for the making and carrying out of comprehensive, internally consistent plans. Rather, when government acts, it is on the basis of compromises that have been reached among competing interests. That system doesn't come without cost, of course, but Banfield concluded that taking the pluses and minuses into account as best I can, it seems to me that government by compromise is a luxury that democracy can and should afford, except possibly in the gravest emergencies of war. Now, the second book I have in mind comes from a distinctly different political perspective, from the left. Hear the People Rule, a constitutional and populist manifesto, was written by my friend and mentor, Harvard Law School's Richard Parker. Challenging the commonly held presumption that constitutional law is higher law, superior to ordinary politics, standing above the fray to protect individuals from the mob of democracy. Parker urged to the contrary that constitutional law should be devoted as much and even more to promoting majority rule as to limiting it. As these 2 examples suggest, one can find on both sides of the political aisle approaches to constitutionalism that are populist, or at least small r Republican or small d Democratic. But by the same token, one need not look too far to find on both the left and the right approaches to constitutionalism that are anti-populist, anti-Republican, or anti-democratic. And thus, the most interesting and challenging debates between competing views of constitutional law aren't those between the right and the left, but rather those among liberals or among conservatives. On the left, such debates happened in the mid-20th century when liberals attempted to navigate a shift from judicial restraint in the Progressive and New Deal era to judicial activism in the 1960s in the Warren Court. An evolution that happened so abrupt that some leading progressives on the left, or progressives or liberals, such as Judge Learned Hand, commonly thought of as the best judge of the 20th century, or the law professor Herbert Wexler, found themselves simply incapable of embracing the Supreme Court's newfound activity, in particular the decision striking down Brown v. Board of Education. Some of the best legal minds of their time were so steeped in judicial restraint that they couldn't accept Brown v. Board, which is, I think, practically incomprehensible to us today. Now, I don't think it's an exaggeration to say that conservatives are embarking upon a similar debate amongst themselves today, judicial restraint versus judicial activism, and that's why I'm here today. A debate that's been limited more or less to academic legal circles and judicial circles is suddenly a matter of presidential politics thanks to Senator Rand Paul. Last month, he gave a speech criticizing the Supreme Court's 2012 decision affirming Obamacare's individual mandate. Specifically, he criticized Chief Justice Roberts, who cast the decisive vote to save the individual mandate by construing it generously as a tax that was within Congress's constitutional powers. A few lines from Senator Paul's speech. Do you know why Chief Justice Roberts did not strike down Obamacare? Judicial restraint. So I guess everybody here is for Obamacare, thinks the court should stay the heck out of Obamacare, the court should stay the heck out, and Obamacare is just fine because the majority wants it. And Rand Paul traced a line of famous or infamous Supreme Court decisions and asked, the question in each of these cases is who should conservatives be for, restraint or activism? Now, Senator Paul's question was strictly rhetorical. Of course, between what he characterizes as judicial restraint and judicial activism, he strongly endorses judicial activism. He calls it as such, judicial activism. He says he endorses the courts identifying and enforcing constitutional rights to strike down federal and state statutes. Now, one can dispute the substance of his definitions, judicial activism and judicial restraint, and I'll get to that eventually. But even just his rhetoric alone is startling. For 3 decades, conservative lawyers, judges, and politicians have uniformly railed against judicial activism. Indeed, the modern conservative legal movement was born as a political force in speeches given in the 1980s by Attorney General Ed Meese, in which he urged that judges' discretion should be cabined by the Founding Fathers' original intentions in order to achieve judicial restraint instead of judicial activism. He said, an activist jurisprudence, one which anchors the Constitution only in the conscience of jurists, is a chameleon jurisprudence, changing color and form in each era. The same activism hailed today may threaten the capacity for decision through democratic consensus tomorrow, as it has in many yesterdays. 30 years later, Senator Paul rejects that rhetorical and substantive preference for judicial restraint over judicial activism, and he's not the only one. In recent years, George Will, who's changed his mind about a lot of things in recent years, has increasingly joined this fight too, criticizing conservatives for what he called their, quote, unreflective denunciations of judicial activism, and he urged courts to recognize and enforce implicit constitutional rights protecting individuals against certain state laws limiting, in particular, their economic freedom. George Will and Senator Paul aren't drawing on blank slates. Rather, they're drawing upon a rich and impressive new body of legal advocacy and scholarship by law professor Randy Barnett, a friend of mine who I admire, litigator Clark Neely, and others who urge judges to practice what they call judicial engagement. It's interesting, unlike Rand Paul and George Will, legal scholars tend to avoid embracing the term judicial activism, given that conservative lawyers are generally averse to the term, and so they use the term judicial engagement. Neely, for example, urges courts to recognize what he calls judicially enforceable unenumerated rights pursuant to the 9th and 14th Amendments. Barnett, somewhat differently, argues that courts should vindicate the 9th, 10th, and 14th Amendments not by conjuring new specific rights, but rather by scrutinizing any federal or state law restricting liberty to ascertain whether the law is actually motivated by purposes within Congress's or the state's constitutional powers, and then investigating whether or not the law sufficiently achieves those proper ends. Barnett calls this constitutional conservatism. I'm not unsympathetic to their arguments. I think I share their premise that the Constitution protects more than just the rights expressly and specifically enumerated by constitutional text as originally understood. For example, to answer a question that journalists seem to love posing to Republican presidential candidates, it does seem to me that an unenumerated constitutional right to privacy would protect people's right to buy contraceptives. And furthermore, it's impossible for me to believe that the 14th Amendment would not legitimately prohibit racial segregation, even if it could be proved conclusively that that right was inconsistent with the 14th Amendment's original meaning. And similarly, it seems to me that Barnett and Neely are right when they argue that the courts must not reflexively defer to federal and state legislators' justifications of their economic regulations, although it is hard for me to say precisely how much deference is too much. It reminds me about the old line about the Supreme Court, how they define obscenity. I know it when I see it, which isn't exactly the best guide for analysis, but I'll stick with it for now. Nevertheless, the growing chorus in support of judicial engagement or judicial activism worries me for at least two admittedly vague, overlapping preliminary reasons. My first concern goes to what Mary Ann Glendon, another Harvard Law professor, in the 1980s called the problem of rights talk. That is, the more that our political discourse tends to focus first and foremost on rights, the more we risk impoverishing our political discourse. Glendon writes that, quote, American rights talk is set apart from that of other nations by the way that rights in our standard formulations tend to be presented as absolute, individual, and independent of any necessary relation to responsibilities. And such an approach in its absoluteness promotes unrealistic expectations, heightens social conflict, and inhibits dialogue that might lead toward consensus, accommodation, or at least the discovery of common ground. It tends towards what she called relentless individualism, and in its neglect of civil society, it undermines the principal seedbeds of civic and personal virtue. My second concern with judicial engagement or judicial activism goes to the nature of Republican government, as famously described by James Madison in Federalist 10. Describing and defending the newly proposed federal structure, Madison wrote, quote, we behold a Republican remedy for the diseases most incident to Republican government. Zealous judicial activism or judicial engagement may well offer a remedy to the ills of Republican government, but I'm not yet convinced that that remedy is a Republican one. Again, Republican in the small r sense. The Constitution's set of checks and balances was erected not to prevent majority rule, but rather to facilitate majority rule, though majority rule in reason rather than in passion. Or if I may abuse my host's generosity by quoting his own words back to him, ours is, quote, a constitution through which the people chooses to limit itself, not by preventing the majority from ruling as in oligarchy, or by retaining a privileged class to rule with the majority as in mixed government, but by constructing the majority so that it will not be factious or tyrannical. I hope I got that right. That's from the America's Constitutional Soul. Simply put, I'm not sure that judicial engagement realistically allows for majority rule in any sense. Indeed, those attracted to judicial engagement or activism would likely say that that's precisely the point, to prevent the tyranny of national or local majorities. So far, conservatives skeptical of these calls for judicial activism or judicial engagement have offered a few responses, but I'm not sure they quite hit the mark. First, some argue over definitions. They reject the notion that reinvigorated judicial protection of rights is actually judicial activism. That is, if the judge is getting the decision right, it's not activist. Judicial activism in this sense only occurs when judges reach decisions inconsistent with, say, the Constitution's original meaning. I used to agree with this, but I'm not sure I do anymore. First, I think this response is ahistorical. The term judicial activism was originally crafted to reflect not any particular judicial methodology so much as judicial activity per se. This point was made well in a 2004 Law Review article by Keenan Kamick titled The Origin and Current Meanings of Judicial Activism. Keenan showed that the term was actually coined by Arthur Schlesinger in a 1947 article in Fortune magazine, and Schlesinger intended it to encompass civil libertarian judges who too often created and enforced fundamental rights against majority rule.
Schlesinger Jr.?
Yes.
Thank you.
I hope so. I think that's.
so.
I think that's who it was. I think that's who it was. 2 decades later, this was more or less the conservative criticism of the activist Warren Court. The Warren Court was wrong not because it was departing from original meaning, but rather the Warren Court was wrong because it was too busy interfering with the rights of the people to govern themselves. And even in the 1980s, when Attorney General Meese was first advancing a jurisprudence rooted in the framers' original intentions, his use of the term judicial activism was clearly focused on the court's anti-majoritarianism per se. In short, while lawyers and legal scholars may well have a precise technical definition of judicial activism in mind, I think the term enjoys broad public appeal precisely because of its more general connotations regarding judges' eagerness to act against popular government. So to argue that Rand Paul's or George Will's definitions of judicial activism are just wrong seems to me less convincing than it used to be. Another response to judicial engagement has been to argue that conservatives should replace judicial supremacy with basically congressional supremacy. That is, we ought to press Congress to more seriously evaluate the constitutionality of its own legislation in light of the Constitution's original meaning. And the courts, in turn, should defer to those congressional judgments so long as the judgments are reasonable. And here I have in mind an interesting and good article by law professor Josh Hawley from National Affairs magazine a couple years ago. Now, this approach certainly would vindicate popular government, but I worry that it might err too far in the other direction. Yes, Congress should take more seriously its own responsibilities to interpret the Constitution and to restrain itself within the Constitution's limits. But then again, we should assume that Congress's normal tendency is the opposite, to push beyond its own limits. Indeed, that's the whole point of constitutional checks and balances, that ambition must be made to counteract ambition precisely because each ambitious branch can't be trusted to restrain itself. So if neither of those responses convinces me, then what alternative would I offer? Well, in recent years, my own thinking has gravitated towards an argument offered by Harry Jaffa in his classic book, Crisis of the House Divided, and by Alex Bickel in books such as The Least Dangerous Branch and The Morality of Consent. According to Jaffa, Lincoln was dissatisfied with views of the Constitution that prized what Jaffa called cold, calculating abstraction above real human experience. Lincoln's solution, as Jaffa saw it, was, quote, an engrafting of the passion of revealed religion upon the body of secular political rationalism. That is, the point was not to prize passion above reason categorically, but rather to channel passion in service of reason. Distinguishing Lincoln from Alexander Hamilton, whom Jaffa called Lincoln's greatest intellectual predecessor in the Federalist Whig Republican tradition, Jaffa urged that Lincoln grasp the necessity of evolving aristocratic restraints upon democracy, not by borrowing contra-democratic devices from a non-democratic past, but rather, and this is key, by evolving them from within the democratic ethos as a perfection of that ethos. That last point, the notion of counter-majoritarian rights as coming from the democratic ethos as a perfection of that ethos, was in turn the premise of Alex Bickel's famous defense of judicial review in The Least Dangerous Branch, namely that counter-majoritarian judicial review can properly exist within Republican government so long as the courts restrain themselves from creating and enforcing rights disconnected from the American political tradition. The courts must be guided in our search of the past by our own aspiration, he said, and by evolving principles which were formed in part by that very past. And to that end, the judges must immerse themselves in the tradition of our society and of kindred societies that have gone before. To Bickel, Brown v. Board of Education was the epitome of proper judicial activity. By the mid-1950s, political experience had made clear that racial segregation was illegitimate. By contrast, the Warren Court's run of decisions in the 1960s on civil liberties, criminal rights, and contraception were not, in Bickel's opinion, sufficiently grounded in that tradition, at least not yet. At the close of his all-too-short life and career, Bickel cast his approach in expressly Burkean terms. On the other side of the debate, he saw a liberal contractarian model of rights, one that saw individual rights as having a clearly defined, independent existence predating society, derived from nature and from a natural, if imagined, contract. Bickel's approach, by contract, begins not with theoretical rights, but with a real society, whose origins in the historical mists it acknowledges to be mysterious. A Whig model that assesses human nature as it is seen to be, a model that is flexible, pragmatic, slow-moving, and highly political, not political in the lowest sense, but political in the highest sense. I wouldn't go so far as to endorse all of his particulars. In his book, his defense of judges as detached, principled intellectuals, or his characterization of judges as, quote, leading a national seminar, makes me cringe. And similarly, Bickel's model presumes that judges can and should and will restrain themselves, which, as I said earlier with respect to Congress, we ought not to rely on. But by and large, I think that his approach helps to not just reconcile law and politics, but to show that there are no real need of reconciliation at all. To borrow Tocqueville's line, which I quote in the paper that was distributed, There's almost no political question in the United States that is not resolved sooner or later into a judicial question, but the emphasis being on later rather than sooner, but sooner or later nonetheless. Similarly, Tocqueville's or Bickle's view of law, lawyers and judges, steeped in tradition and precedent, also seems consistent with Tocqueville's appreciation of what he called lawyers' habits of order. Although, again, I think such generalizations about lawyers and judges' habits shouldn't be taken too far. You spend enough time around lawyers and judges, you become a little bit less, you become a little bit more suspicious of their so-called habits of order. But let me offer a couple of modern examples. In recent years, I found the best example of this approach is found in the decisions of Justice Alito on matters of the First Amendment. A few years ago, in a series of cases involving aggressive protests at military funerals, unprecedentedly violent and immersive video games, and disturbing crush videos, which I'd rather not explain what they are, but if need be, I will. Alito's analysis began with textual analysis of the First Amendment and of free speech doctrines, but finding those texts and doctrines insufficiently controlling or instructive in these controversies, Alito urged the court to leave greater room for states and local communities to regulate these matters according to local sensibilities and customs, before ultimately venturing to impose a one-size-fits-all legal solution on the country as a whole. He wasn't saying that the time wouldn't come for such a one-size-fits-all approach, but just rather it shouldn't come quite yet. Another example of this approach might be the Supreme Court's decision in NLRB versus Noel Canning, in which the Supreme Court struck down President Obama's unprecedented efforts to unilaterally declare the Senate in recess and then recess appoint officers without Senate confirmation. In that litigation, the lower court wrote an opinion in strictly textualist or originalist terms, analyzing the constitutional provision, namely the phrase, "the recess of the Senate," interpreting that phrase almost abstractly. But the Supreme Court, by contrast, was much more comfortable in recognizing and reinforcing pragmatic limits or pragmatic lines, defining recess as loosely as a number of days, lines that had been developed over a century of practice by the political branches, by Congress and the President. I'd caution that it's impossible to map this approach to deciding individual cases. It's a set of values or habits, but it's not a self-executing rule for deciding cases. Nevertheless, I think we ought to pay heed to Bickle's approach because, if nothing else, because of the context in which he developed it, namely that moment at which the left was evolving from a constitutionalism of judicial restraint to one of judicial activism, although perhaps liberals at the time would have preferred to call it judicial engagement too. The left had developed their theory of judicial restraint first in the Progressive era and then in the New Deal era, when it saw courts as too often thwarting the political process. But by the 1950s, when their focus turned especially to problems of racial segregation in the states, the left suddenly began to see the virtues of judicial protection of minority rights and soon followed that with criminal rights and privacy rights. By the end of the 1960s, of course, the left would favor full-throated judicial supremacy. It was a treacherous evolution. Some, such as Learned Hand, the progressive, could not give up their initial attachment to extreme judicial restraint and end up discrediting themselves by failing to recognize the legitimacy of Brown v. Board of Education. On the other hand, so many on the left erred too far in the other direction, imposing judicially created rights on the public so aggressively that they wound up discrediting themselves among the general public, ultimately giving rise to the election of Nixon and Reagan and so on. Now, Bickle wasn't the last to conceive of judicial law in such terms. Much more recently, Peter Berkowitz published a short but fascinating book titled Constitutional Conservatism, the same term claimed by Randy Barnett and others proposing judicial engagement, although I'm pretty sure that Berkowitz coined the term first in 2009 with essays in the Wall Street Journal and Policy Review. Drawing on Burke and Tocqueville and the Federalist Papers, Berkowitz, much like Bickle, urges an approach to constitutional law that's rooted not just in abstract principle, but also in prudence and in practical experience. I'll close with three final thoughts. First, if Bickle and others are correct, that rights ultimately must be anchored largely in political tradition revealed over time by the political process, then courts do need to step in and take care to help protect the structure of the political process, namely the system of checks and balances, separated powers, and federalism. If those institutions are allowed to collapse in the name of democracy or majority rule, then our politics, I think, will be a poor expositor of fundamental principle. Second, I think that this approach requires us to concede that the work of courts is not merely to interpret legal texts in the abstract, but rather to conduct such interpretation self-consciously with an eye to the court's own place in the political and legal process. This is anathema among conservatives, especially right now, in the aftermath of the Obamacare decision. In that case, Chief Justice Roberts was seen as corrupting his legal duty by deciding the case with an eye to the court's own constitutional and political legitimacy. Now, whether or not the Chief actually did calibrate his legal analysis in light of worries of a political backlash against the court, and that's a narrative that I tend to doubt, although who can really know. The fact remains that conservatives by and large believe that Roberts pulled his punches for political reasons, and I worry that conservatives will conclude, based on that regrettable experience, that courts should never approach the task of legal interpretation with an eye to the court's role in the political system. The court should never defer to elected branches, should never construe statutes where reasonably possible to avoid constitutional defects. My third and final thought is that conservatives' embrace of judicial activism or judicial engagement could, if taken too far, effectively mirror the left's excesses on matters of regulation. Far too often, the left seeks to remove issues from politics altogether, to commit them to so-called expert decision makers, to be decided without the corruptive influence of politics. Ironically, those on the right who are most eager to criticize this tendency on the left tend, I think, to be the ones most eager to remove the Constitution from the political process and from political experience, and to commit legal and constitutional issues to experts in the law, namely judges, with all due respect to judges, and to legal scholars, free from the corruptive influence of politics. I think that extreme would be a mistake. And for that very reason, I'm pleased to be here today to discuss all of this in a forum expressly dedicated to preserving the connection between the Constitution and politics. Thank you.
Well, thank you. Wants to ask a question? Yes, Peter. Peter Hansen.
You quoted Harry Jaffa on Lincoln's emphasis on revelation, but then your discussion of Jaffa focused on aristocratic restraints on majority will emerging from the majority itself. So is revelation, faith in revelation, an aristocratic restraint on the majority? Do you think it's a necessary basis?
Well,
restraint on majoritarianism?
I could be misreading Jaffa, but I took him to mean revelation to not the aristocrats, but revelation to the people, the individual level. That each of us experience revelation, whether in religion or in constitutional law, and that we're entitled to contribute our voice to the process and not have these matters determined by our superiors.
Then, if faith in revelation, which I took Jaffa to mean there primarily biblical revelation, if that's a cornerstone of restraint on majoritarianism and self-restraint on majoritarianism, is it a cause for concern that that sort of faith appears to be diminishing? American life, church attendance going down. Say nothing of European.
Well, I should be clear. Jaffa was speaking in terms of Lincoln's experience at the time. I don't think he was trying to connect it to religious faith in the modern sense, and I didn't mean to suggest it as such. I'll be honest, I don't know how the decline of organized religion maps to the decline in maps to the questions of constitutional law. On the one hand, as your recent speaker, Francis Fukuyama, points out in his new book, organized religion itself is a major contributor to the appreciation of the rule of law, and so maybe a decline in religion would have similar impacts on appreciation of the rule of law, but I guess I just don't know. I'm sorry not to have an answer, I just don't know.
Yeah, Rory.
On a sort of basic level, activist versus restraint, plausibly empirical, and we can make sense of it. But in a way, it makes me wonder whether if you push it, it's any more useful than a term like violent extremist, which sort of begs the question as to what one is extreme about.
Sure.
I suppose violent, but extremist. I mean, I'll just give two current case examples, and you might know the details better. You can correct me if I get anything wrong, but the one that's going to face the Supreme Court regarding the Affordable Care Act regards the way in which the executive branch is enforcing or carrying out the law, and also a federal state issue. Now, if the court rules against the government in favor of the states, or if it rules for the government against the states, I don't see how you could easily say whether it was acting anti-majoritarian or majoritarian. It seems very complicated. It is an elected president. He's the most nationally unified single elected representative. On the other hand, the states seem to be much closer to what you'd call majoritarian government. The state legislatures have passed laws or have refused to go along with the mandate. So I don't see how anti-majoritarian or majoritarian helps you there. And to take a different example, the gay marriage case law, I don't know the exact latest case, but when it reaches them, and it will, let's say for, just for supposition, a ruling of the Supreme Court is that gay marriage needs to be, which is recognized by the federal government, needs to be legally recognized by all the states in the union. Now, again, I would ask, is that an activist decision? And I don't really understand, based on what you said, how one would characterize it as activist, as anti or pro-majoritarian. It seems to me that the liberal justices on the court would say the following: many states have passed these laws. Maybe they'd even say a majority of states. They would take that as a big reason to vote, or to decide in favor of gay marriage legalization. And also I think they would say, well, the pulse of the nation, we can see a social evolution of opinion regarding gay marriage, and so I thought, maybe in 1975 they thought it should be legal, but they wouldn't have ruled. But now, okay, they're a little bit out ahead of public opinion, but they want to ratify that opinion and push it and have a public effect. So again, are they majoritarian? It just seems to me that the majoritarian, anti-majoritarian criteria doesn't work for either of these big-ticket cases. And I just wonder,
No, it's a fair criticism, and I tried to anticipate it a little bit near the end of my remarks when I said that I'm not suggesting that Jaffe's, Bickle's, anybody's approach along Berkowitz's approach lends itself to sort of an easy rule of decision in any case. You could have in the same case, you could have a judge on the right think that he is implementing this approach and arriving at one decision. You could have another judge, whether liberal or conservative, reach the actual opposite decision in the same case by applying what he thinks are the same basic principles. I'm not trying to suggest that this is a replacement for originalism in the sense that you have sort of a straightforward methodology you apply and you get an answer. Rather, what I'm trying to do is highlight a set of values which I think are underserved in current constitutional discourse that deserve greater attention, greater consideration, but which don't obviously control in either direction in any one case. It's not very unsatisfactory. And in fact, I think that's why Bickle's vision ultimately failed at the time. It's interesting, when he passed away in the 1970s, he died very young, he was perhaps the most prominent conservative law professor in the country. George Will wrote a column saying that he was the keenest public philosopher of our age, and Robert Bork, his close friend, Bickle's close friend, said that Bickle's approach would be sort of the benchmark, the guiding star of an entire generation of conservative constitutional law. That proved completely wrong, right? Within 10 years of Bickle passing away, his approach had been superseded by originalism, which did appear to lend a straightforward approach, an easily administrable rule that could decide individual cases. What was the framers' original intent, or what was the law's original understanding? Apply it, you have your answer. In fact, Bork ended up leading that movement more or less, supplanting Bickle. But I think for all of its success, and I do consider myself an originalist, my first instinct in analyzing a legal text or arguing a legal case is what was its original meaning, its original understanding. In spite of all of that, I think that taken too far, taken too far and setting aside these other values that deserve consideration, the risk is that originalism becomes an inflexible rule that's too self-confident in its own ability to decide cases. Now, how all of what I just said, for all of its mushiness, how it maps on to King v. Burwell or the same-sex marriage case, I'm not quite sure. I'll admit in King v. Burwell, the healthcare exchange case, I filed a brief, or my firm filed a brief in that case, arguing that not repeating the main merits of the claim, namely that the administration is violating the plain text of the statute, but rather urging the court that in addition to that reason, the court should be further skeptical of the administration because the administration's position would severely undermine notions of federalism. That the administration's position runs roughshod over federalism, pushes them aside, doesn't just subsidize the states that didn't want the subsidies, but punishes the states that didn't opt into the system by putting extra burdens on them. And so we were trying to bring this additional value to the discussion. I mean, ultimately, in a given case, originalism may well be the best decision. In fact, I personally believe it should always be the first instinct of judges to go for originalism. But my goal is to say to judges and scholars that when originalism doesn't get you all the way there, that it doesn't quite answer the question you're seeking to answer, much as it didn't in Justice Alito's opinions in the First Amendment cases, the court should be mindful of these other considerations, notions of judicial restraint, of the court's role in the political process, and the need for courts to not get out too far ahead of the public in terms of conceiving rights, but rather to anchor and restrain themselves somewhat in the rights as revealed by political tradition and political experience.
Tom?
I also want to question this restraint versus activism divide as not necessarily being helpful. And it seems to me that this debate will have to continue and there won't be a resolution to it for the following reason. Both the originalists, the predominant conservative side, and the other people have tended to reject the notion that there are standards outside of positive law that can guide judges in making decisions. And it looks as though part of the story is usually that the liberals are making stuff up. They have their preferences and they're trying to impose them on us. And the basis of that thought is sometimes that they accept that judging is a form of lawmaking or legislation. That is, they're positivists of some kind. Whereas originalism is on the side of restraint insofar as they're not getting into that nasty business that they don't have any role in. But on the other hand, they too are positivists insofar as they just say, this is the positive law and we're just going to carry it out. And you
Conservatives say that.
Conservatives say that, right? Originalists, strict originalists. And it seems to me if that's the way that the debate stands, if both sides reject or do not share any notion of natural law as existed in the common law tradition, which is deteriorated over the last 100 years or so, or a notion of natural right that I think Harry Jaffa, for example, would refer to. If there's not any agreement about that, you can refer to, it's clear you need something other than positive law. You can refer to political traditions or the evolving standards of judgment that are coming clear over time, but there's not going to be any possible agreement over those things, and both sides are just going to see each other as using their political will to overcome the other side. So
it's a fair point, although I'd add that even in the in current debates, like you say, there's no agreement. In fact, at this point, liberals are largely adopting the rhetoric and to some extent the substance of conservative originalism, yet achieving reliably liberal results. The case of the gun case, Heller versus D.C. or D.C. versus Heller, it was a pretty fascinating case. You had Justice Scalia writing for the majority, recognizing individual right to own guns. You had the dissent, I think Justice Stevens, conducting, an extensive originalist sounding analysis into the original meaning of the Second Amendment and reaching precisely the opposite conclusion. And so I don't know that even if you had sort of nominal agreement on your premises, I think the disagreements would still be manifest. But I'd add that in any given case, even in the Supreme Court, even with an ideologically divided Supreme Court, you don't always see judges lining up the same way. You don't always see judges acting consistent with their own previous decisions. And in some ways, their analysis is either explicitly or sometimes implicitly directed by their own experience. I guess what I'm saying is, in any one given case or any year of cases, you're going to have disagreements, sometimes logically consistent, sometimes logically inconsistent. My goal is, over the course of years or more, that series of fights within the court and around the court will ultimately give rise to principles that the public and the court can settle on and agree upon, even if they don't agree on the approach, right? Whether you agree that the 14th Amendment protects, the 14th Amendment forbids segregation because that's an originalist interpretation, or the 14th Amendment protects you against segregation not because of originalism but because of a living constitution or something. At the end of the day, the public more or less arrived at the same place. And I suppose that's the best we can hope for, is that over time we converge upon principle through the political process, including the courts, even if we don't agree on how we got there. Is that?
I mean, yeah, but that seems to me that's something like that is the best option. But that just seems to me you're saying what people happen to believe at any given time is going to be what rules, and that's maybe that is what happens. But that doesn't seem to me a great solution. I mean,
Well,
why is the fact that many people tend to agree about something for different reasons good?
Well, that's a fair question. I don't know that it's, maybe it's a mistake for me to say that it's good. I guess it's a good question. I guess maybe in the end it beats, maybe this is just my own sensibility, but it beats the alternative, namely relying on judges to just sort of tell us, we'll decide this for you, and we know how. I don't know, it's a very challenging question.
Tom Palmer.
This is a semantic question. The terms have always confused me because you sort of come back on yourself here. It seems like if you're an originalist, that's not activism. I mean, it's more undoism or something, but the left seems to always win points by accusing the right of being activists when they've been wounded by that term themselves with the public. And I don't know whether there's a way to distinguish originalism from activism that then rolls back something that went against the originalism.
Well, each time I've used the term in this discussion, I hope it's been surrounded by sort of imaginary question marks, because I think it is a term that gets thrown around largely to criticize one's opponents. You said when you think of originalism as not as activism, because I guess your premise is that originalism is a methodology that actually constrains judges in the exercise of their own discretion. That's, I think, the general presumption of originalism, and it tends to be my own, although you then see judges, both conservative and liberal, sometimes applying originalism in a way that I think lends one to think that they're not actually cabining their discretion. I guess what I'm saying is over time, it's less and less clear to me that originalism, as broadly understood, actually is a check on judges' discretion, that there's enough play in the joints that originalism might get you to a certain point in the debate, but at the end of the debate there is this remaining amount of discretion that really can't be settled by resort to originalist methodology. And when you reach that point, if you do reach that point in a case, the question is what takes you the final mile, and that's the point at which I would seek to insert this Bekelian or whatever you want to call it approach of not getting too far ahead of tradition and the public in crafting counter-majoritarian rights.
Ed.
Well, my con law professor, I was too late to get to have Professor Bickle, but Charles Black, who was one of those kind of liberals who liked restraint, I think, and was bothered by some of the Warren Court decisions, he had this notion of proportionality, and is the legislation disproportionate in some way, and that led him to be able, I think, to separate instances where the courts could take a more muscular approach if the legislation was disproportionate, or should exercise more restraint. And that might explain, for example, the voting rights cases, why the same legislation that's constitutional in 1966, because it's a proportionate response, is is disproportionate today and is unconstitutional. Is that similar to, in some ways, to what you're talking about?
Well, I guess it means I guess the answer is disproportionate to what, right? Bickle's response his approach wouldn't be, is this disproportionate to, current political sentiment per se, but rather is it disproportionate to the political tradition sort of more deeply felt. I will say the approach the Black's approach as you described it, it's very much present, and it will be, I think, a central issue in the same-sex marriage case. There's an argument, I think the most successful argument in same-sex marriage has been that the court should affirm the right to same-sex marriage because the state laws outlawing same-sex marriage are intentionally, they're punitive, right? They're punitive not just to the couples that want to get married, they're punitive to the children of same-sex couples. This is an argument, I really saw it bubbling up for the first time about a year ago by another Yale professor, Bruce Ackerman, started advancing it in his latest book, and others have grabbed a hold of it. Justice Kennedy, it's really directed, they think, at Justice Kennedy. I'm going to have to go back and read Black because it's interesting. I do think, so I guess the point is, I do think that approach has adherents. We'll see it in same-sex marriage, but I have to admit, maybe this is just my own bias, I'd have to think that Bickle, were he here today, I don't think he would favor the nationwide constitutionalization of same-sex marriage today. I think he might 40 years from now, in the same way that he might today approve of the right of privacy in a way that he didn't in the 1960s. But again, it's because these rights are being judged not in the context of just a momentary snapshot of public opinion and is it disproportionate to the immediate circumstances, but rather how is this view of rights sort of mapping to the longer sort of arc of political tradition.
Okay, go ahead. Go ahead, Reed.
Well, I wanted to ask actually a question that was similar to Tom Cleveland's, but stated maybe a little bit differently. So what you're describing, this kind of Burkean movement that's supposed to restrain judges and give more sway to the people, is it anchored in anything? So I'm not suggesting natural law or natural right, but even fundamental constitutional rights that even if the sort of drift of the people or the state legislatures or the federal legislature were to move against, that the judges would have to, I guess, defend or protect? Because it doesn't seem from what you said that, I mean, so you mentioned George Will's fundamental individual economic rights, which recalls to me Lochner, which was the first activist decision in some sense, right? And so are there rights? Are they the constitutional rights? What are the sort of fundamental barriers that even the judges can't cross to move with the people?
Would it be wrong for me to put the question this way? Is this vision of constitutional rights a one-way ratchet? That once the courts have identified and established and affirmed a constitutional right, that there's no going back, that even if the public begins to sway in another direction, the court then has to sort of defend against...
Well, I'm asking you whether you...
No, I just want to make sure I understand your question. I think the answer would be no, it would not be wrong for the court to reevaluate its precedents in light of the further progress of political experience. And I think actually the Alito opinions I was talking about are a good example of this. I hope I'm not misconstruing them. It's that, over the course of 100 years, the First Amendment doctrines, progressed in a certain direction. We found ourselves, today with a body of case law that's very sort of emphatically protective of speech, not just the words coming out of your mouth, but conduct and other things that are treated as speech. But these new cases, Alito thought, raised questions that really weren't answered sufficiently by the old doctrines. They raised doubts about the doctrines, right? Sure, we look very dubiously upon restrictions upon video content or books and so on. But are these immersive video games? Are they just like books, right? Scalia's opinion for the majority said, these hyper-violent immersive video games are no different than Hansel and Gretel, right? There's always been violence. Kids have always been. This is literally what he said, that kids have always been exposed to violence in their entertainment. So there's nothing new here. The old doctrines clearly solve this question, let's move on, where Alito said the old doctrines were established to answer specific questions. They came up from that. These are new questions, new practical questions that aren't really answered by those doctrines. And I think that's what would happen, is that it wouldn't be so much that the public would, out of nowhere, decide that suddenly we like economic freedom more than we used to, as an abstract matter, but rather the public would gravitate towards new economic freedoms due to new political experience, whether it's newly, unprecedentedly heavy-handed regulation of economic rights or economic activity. This was somewhat, I think, in play in the individual mandate case, where if you looked at the individual mandate as just a regulation of commerce, well, then the old doctrines would pretty clearly affirm the Obamacare individual mandate. But it was only the people that said, no, as a matter of fact, the individual mandate isn't really about regulating commercial activity. It's about regulating commercial inactivity, a distinction that we'd never really had to grapple with, a distinction that some saw as completely irrelevant or immaterial, but a distinction that others on the right thought was very material. It was that kind of factual change, or that sort of new circumstance, which led to, a rollback in some sense of the right in question, or the government power in question. Does that answer your question? I hope a little bit.
Oh, question over here now.
Could you work Citizens United into your analysis?
Yeah, that's a fair question. I wondered if maybe somebody would ask this after I said that the court needs to help defend, in some sense, the political structure in which values are enunciated. Because some might say that Citizens United didn't do that, that you need more aggressive campaign finance regulation precisely because you need to maintain sort of the viability of politics. I have to admit that while my initial instinct is not necessarily to say money is speech, but to be skeptical of the role of the government regulating campaign finance, I have to say in the modern era with these immense sums coming in through super PACs and other organizations, ways that really do sort of challenge, that change the balance of various groups and individuals' roles in the political process. I hope I'm not struck down for saying this, but I'm at least open to the idea that the new circumstances call for an open-mindedness towards new forms of regulation. I'm not exactly sure where I come down on this. I guess to answer your question, I would say whether or not Citizens United was rightly decided, it wouldn't be wrong for the public and the court to sort of re-examine how they conceive of money in politics and the extent to which the public's ability to fund political campaigns or other activities, it should at least be examined. I think at the end of the day, I might wind up in the same place as we are now, but I'm at least willing to have the conversation.
And you wouldn't be surprised if Anthony Kennedy, the deciding vote in that case, in a similar case in a few years, reverses himself.
Sure. In say 3 or 4 election cycles from now, if it does become the case that each presidential candidate is effectively supported through the primary process by one sort of champion supporter, right? We saw this in the last round of Republican primaries where each candidate seemed to have his own
Billionaire.
his own billionaire. I mean, if that trend continues and that trend is seen by the public and by the courts as having a, to borrow your term, disproportionate impact on politics, then I could see the court reevaluating its own approach. It reminds me, I've written a few pieces on Alito and Bickle, just little magazine articles or whatever, and one time I titled it, a piece on Alito, I used, was it Lord Keynes's line that when the facts change, I change my mind, what do you do? I mean, there is some thread of that in this approach to constitutional law, that experience comes out of the practical facts of the matter, and as the facts change, it's not improper necessarily for the court to change its mind.
Yes,
Do you
Tom.
think that transparency is an answer to that problem, if it is a problem?
It could, well, this is a circular answer, but yeah, transparency could be an answer to the problem if if it proves to be an answer to the problem. I guess it depends on how you define what the problem really is.
I had a question about, oh, Jim, you go ahead.
So you mentioned the Ninth Amendment before, and as I understand it, it's never actually been cited in a Supreme Court case. I was wondering how you think the Ninth Amendment can be used without it becoming Pandora's box.
Remind us what the Ninth Amendment is, please.
The Ninth Amendment says that I hope I don't get this wrong and confuse it with the 10th, but the Ninth Amendment, the enumeration of rights
Yeah,
should not be construed as disparaging other rights held by the people or by the states. Right? The Robert Bork, I think, famously compared to an ink blot. It's so impenetrable, we can't understand. It's as if there were an ink blot of the Constitution. There's no sense in trying to administer it, to interpret it. Randy Barnett, in the pieces that I was talking about, said that the best way to vindicate the Ninth Amendment is not by trying to come up with rights, right, in the abstract, but rather to just really strictly investigate laws, right, to really put Congress and state legislators through their paces in defending their laws, and that process will, in the end, defend liberty. For me, I guess this was the point of my fondness of Bickle's approach, is that I think the Ninth Amendment is broad enough to encompass, substantive rights that aren't enumerated in the Constitution. Maybe that is the right to privacy in some sense. Maybe it belongs in the Ninth Amendment. But I don't trust my own capacity for sort of divining these rights in the abstract, just as Bickle said he didn't trust himself or didn't trust courts. And so as this process plays out and the courts find it sort of impossible not to recognize a right, whether it's a right to against segregation or a right for contraceptives or whatever, maybe that's how the Ninth Amendment is best vindicated.
I have a question, or maybe a two-part question about law, or the nature of law. What about the respect that is due to the law as such, the need for obedience and the habit of obedience, and by obedience one means unquestioning obedience. Well, you can question in your mind, but the law's effect, even if they change the law, is to demand really that it be obeyed, and this demand can't be entirely rational, because any principle or reason that you give is going to deviate at some point from the law as it is. So doesn't this nature of law as a fabric which shouldn't be broken, doesn't that have an effect on the theory or principle or model one would bring to the interpretation of it? And the second part is that on the other side, you might say that the progressives began with the notion that progress required changing the law, and changing it in recognizable ways, so as precisely to create a break from the past. I think the theory they used was legal realism, which you haven't commented on. And legal realism would say that it's the only realism about the law is to understand that it's the consequence of something which is stronger than the law, and and that can be philosophy or economics or history or whatever, and those in combination could be added up to the progressive platform, but also you might say to the counter platform of conservatives who oppose progress. So isn't legal realism a kind of challenge to the nature or conventional nature of law as a whole, as a fabric. And if progressives are going to make a point of denying that, then is it really activism in the same way to actively oppose it?
Well, on the first law and the role of obedience, the need for obedience, I mean, I have to admit, I haven't thought this through. My own instinct just sitting here is I do believe, I'm attracted to the thought that the law requires strict obedience, that civil disobedience, to the extent that it's justified, is only justified in the same way that, say, presidential emergency powers are justified. I wouldn't exclude them altogether, but I would sort of try to cabin them as much as possible in favor of the broader rule that the law should be obeyed. And I do think, to get to your point, I do think that does inform my own approach to constitutional lawmaking, namely that since we're going to be stuck with these rules and we ought to obey them and they ought to be enforced vigorously, that we ought to tread very lightly before allowing judges to sort of unilaterally craft those rules. Now, of course, judges in any case, or almost any case, or at least the hard cases, are always left with a small amount of discretion that effectively amounts to lawmaking. But in the creation of constitutional rights, especially broad constitutional rights, that are going to be of such binding effect, I think it is that binding effect that ought to inform us or encourage us in treading lightly and letting judges create the rules. Legal realism, maybe this is what you're alluding to when you talked about laws understood in terms of its practical impact. I mean, that was Justice Oliver Wendell Holmes' favorite line, right? That the law ought to be understood as that which will force the bad man, as he put it, to change his conduct. That is strictly the lens in which you evaluate what the law is. And your question was, I mean, if you wouldn't mind repeating it, your question was that if that's how liberals see what law is, namely the set of societal consequences and tendencies that affect people's conduct, does that inform their interpretation of what judicial activism is? Is that?
Well, yes, they would embrace that as, and this would be perhaps an advance on the definition of judicial activism as that which not only doesn't fear to make a change, but embraces it and announces it, and that's because the law would want to establish itself as progressive, and progressive means new, and new means different.
Yeah,
Different means revolution or some kind of break with the path.
I suppose, yes, I suppose that is how they would see it, and I think that's manifested in what they criticize as judicial activism, which tends to be conservative judicial activism as they see it, in service of constraining progress. Whether it was conservatives of the progressive era striking down state legislation protecting workers, whether it was conservative justices on the Supreme Court in the New Deal era pushing back against the New Deal, although liberals in the court pushed back against the New Deal too. Whether it was conservatives in the 1990s on the Supreme Court, a conservative majority that came within a hair, people thought, of striking down, of rolling back Roe v. Wade. It really is activism in service of what the left would characterize as anti-progress.
Yeah, so I would think, and that from this point of view, sort of Bickel's appeal to history would be inadequate, because there's two different kinds of history. There's the history of the common law, in which legal interpretation tries to find some way of reconciling the new with the established, and then the history of progressive legislation, something like the Warren Court, which is sort of deliberately progressive or revolutionary, in which does not try to find a place for the new in the old, but makes a distinction.
Well, I'll say, actually, Bickel's approach, and for as much as he described, he talked about tradition, he also had an eye to progress. He was a progressive, right? He clerked for Felix Frankfurter, I think. He saw himself in his career as a progressive. And these are the parts of his analysis that I cringe at somewhat. It's not just that the Supreme Court is looking to tradition, but the court is, in some sense, at the vanguard, sort of leading the national discussion in terms of tradition, sort of poking and prodding gently the public to accelerate some might say, I guess, the arc of history. Those are the parts that I sort of shy from, but Bickle didn't. And that's one of the interesting things about Bickle, was that he came up as a progressive, a self-styled progressive, at the beginning of his career. Near the end of his career, he was a vocal, self-styled conservative, and you had a lot of his friends say that he had changed over time, that John Hart Ely said that Bickle changed over time. My position in a piece I wrote for Commentary was that the substance of Bickle's thought really didn't change over time. That Bickle, the threads on tradition and so forth, that he really was focusing on near the end of his career are also present in his earlier books. But I guess where I'm going with this is Bickle himself, Bickle's Bickellian approach, would feel perfectly comfortable melding both tradition and progress. He saw the two as inextricably intertwined. I'm less confident in that.
And let me ask, too, about another sort of related point from Locke. John Locke thought that a free society should be one in which the laws are legislated. And so he made a great point of the sovereignty of the legislative power. And this would be as opposed to a common law society where the law doesn't change, but simply grows. Yet, he also spoke of the need for, quote, settled standing laws. That is, they mustn't change a lot. So, the legislative power is there, but they mustn't change a lot. And then today you get this, I think, in something of the libertarian view, that the law must be such that you can expect what is and what isn't legal. So as a citizen, you can act on the basis of a sound expectation without having the government say, always changing the income tax or the taxation legislation. You don't know what to do.
Well,
because that leads to retroactivity. Yeah.
I mean, the libertarian approach, I think it neglects the fact that fundamentally one of the rights that we hold or ought to hold is the right of self-governance, right? And so there is that. I mean, I guess not to turn and ask the question for you, but since I'm, needless to say, no scholar of Locke, how does Locke's view of executive prerogative fit into his view of sort of legislative supremacy?
By counteraction. So, counteraction or contradiction, you could say that. It's a reasonable view that you need a standing. A law isn't a law unless it's settled and standing, but you need exceptions because emergencies arise, and they arise because human affairs are not totally predictable.
I mean, in my little world of law, I mean, it's the distinction between Jefferson and Madison, right? Jefferson, who thought that all laws should be sunset after 26 years or whatever, and Madison, who thought that while he was in a while the framers were self-consciously creating a constitution, sort of paradoxically, they wanted to create a constitution that future generations would hold in reverence and be slow to modify.
That's right, in veneration. So maybe then the answer to this is to make a distinction within law between ordinary law and constitutional law. So the Constitution is venerated, but the ordinary law, that's up for grabs.
Maybe, but it's interesting. I mean, the left in some respects has embraced that view. That's Bruce Ackerman's theory, right? Maybe you all know this. I don't know, but of constitutional.
No, we don't know this.
That there's ordinary politics and then there's constitutional politics. So there's ordinary lawmaking and then the higher lawmaking of.
But he fuses the two. He wants the Constitution to come out of political.
Yeah, but not all political, right?
No.
Only special political moments that he happens to like.
Big ones.
Right, but big ones. Big ones in which the public, as Ackerman says, is sort of self-consciously engaging in a bout of of detached higher lawmaking.
Yeah. All right. Yes, Keith.
So I wanted to go back to your paper that was distributed too. I was thinking in response to Harvey's first question there, the other extreme would be the apocryphal comment attributed to Aristotle of what is the profit of philosophy? It's that you learn to follow the law without being told, right? So the exact opposite of obedience at some level. But that obviously doesn't work for a community as a whole. So when you were talking about profession, I'm wondering what element does profession play in helping to create the kind of legislators or judges that would have this kind of rich sense of politics that you're advocating? Does it have any part to play? Are you very pessimistic about that? I was struck by your papers saying Tocqueville was wrong about lawyers. And
Well, he was right at the time. I'm just
Yeah.
less confident that he's right now.
Right. I mean, should we have philosophy classes for law schools, and that's going to somehow help, or is it
I think
really
it's
something much more nuts and bolts than that?
I think it was something instilled by culture that being lost will be hard to retrieve. Maybe I'm imagining a distant sort of perfect moment in the law where lawyers really did, really did sort of exemplify habits of order in which their approach to legal analysis was appreciative and it was appreciative of precedent, not merely in form but actually in substance. Maybe that is all. That's a remembrance of a past that never happened. But I think it happened. If Tocqueville said it, I trust that it happened. I just don't see it as much today. I think in part it's the impact of legal realism in the 1930s, the notion that the legal realists' notion that in the prior century, when judges went about the task of finding the law, they weren't really finding the law. They were creating it, and in fact, they were self-consciously creating law. All the thing about finding law was just rhetoric. I think my understanding, I do think in the 19th century, lawyers did see themselves, at least in no small part, undertaking the task of finding law, finding it in the common law, and that's just simply gone now. It's one of the reasons why I worry that the longer that originalism is on the scene, the less it will actually restrain judges, because judges, in particular, my political bias, but judges on the left, will become more and more accustomed to speaking speaking originalist language while pursuing an actual, anti-originalist agenda. And so I guess that's where my pessimism came from, is that in part it's that lawyers aren't steeped in the same culture they used to be, but also that the legal profession, the law is more and more of a business, less and less of a profession, for better and for worse. The clients prefer it this way. When law was a profession, it was a very expensive profession. It's becoming more of a business, probably for the better of the clients. But the legal profession or legal business no longer reinforces the same values that it used to. Not just values of how lawyers ought to go about their work, but how lawyers ought to conduct their lives, how lawyers ought to see themselves not just as lawyers on the job, but lawyers in the context of a civil society, lawyers who are deeply embedded in that and who work towards public good in terms of civic engagement, things that lawyers today are just too busy really to do at most firms. I'm very worried about the future of the profession and its ability to create and foster a state of mind that's not right, to foster a culture that I thought used to do the country a lot of good for exactly the reasons that Tocqueville had identified.
Yes, right.
So this backdrop of Tocqueville, his analysis of the United States constitutional order was supposed to be instructive to other orders, especially France. I wonder how much, I say this as a Canadian, and the Canadian Constitution is only a little bit older than me, maybe 1 year older. How much of this analysis is, of course your analysis was centered on America, but how much is it exportable? The originalist position seems odd to me because it seems to grant the founders a kind of divinity of some almost. But it's also I think more straightforwardly problematic because it doesn't seem like Dred Scott can be opposed on originalist grounds. And so it seems to me that Lincoln was not an originalist, or he appealed to Declaration, which is not in the Constitution, and the Bible as well. So is some of the difficulties that you're grappling with here, are some of them because of the particular American experience that you have a Constitution, which is the outcome of a revolution, and so conservative jurisprudence is the defense of a revolutionary document, and therefore one is placed in the odd position of being conservative and defensive, not of canon law here. I mean, it's not the Magna Carta.
There's so much there's so much to impact there's so much in that question that it's hard to know where to begin. I mean, I'd say, one, that originalism is successful in American culture in a way that I don't think it would necessarily be successful in other cultures, precisely for the reasons you identified, that we do venerate our founders, that the notion of asking what did the founders mean, or what did they intend, what did their words mean, has a greater cultural and political salience in the United States than it would in, say, perhaps in Canada.
Because in Canada, the son of the gentleman who authored the Constitution may become prime minister. So.
Of course, I mean, the United States went through that itself, right, at the dawn of its revolution, and Jefferson and others would be perfectly happy to point out at the time. And so, right, I don't think originalism isn't a one-size-fits-all remedy or approach for all countries, and it's probably uniquely well situated in the United States, and it's hard to imagine it mapping anywhere else. Even in Tocqueville's time, I mean, not only am I not a scholar in Locke, I'm not a scholar in French history, so I don't know what the state of French politics was at the time that Tocqueville wrote it. But was it then a civil code country in the way that it is today? I mean, in that respect, any comparison, any sort of virtue that Tocqueville saw in the common law was sort of inherently inapplicable in France, since they just simply didn't have that system. There was one other part in your question that I really wanted to answer, and now I've sort of talked myself out of remembering what it was, maybe intentionally.
Dred Scott, the Lincoln issue?
Yeah, well, I mean, maybe Lincoln's view was he appreciated the founders because he'd say, this could be wrong, but they built better than they knew, right? That with the Constitution itself, the Constitution sort of taken as a document might not squarely oppose Dred Scott, but the Constitution as informed by the Declaration of Independence, instilled with those values, sort of would inevitably lead, it set the country on a course that would inevitably lead to the eradication of slavery. And that in that sense, Dred Scott, in standing in the way of that, by denying that premise of the Constitution, was contrary to the Constitution and contrary to the founders. But Lincoln, I mean, that was part of Jaffe's book, was that Lincoln, for as much as he grew out of the tradition of Hamilton in many respects, was deeply at odds with Hamilton to the extent that Hamilton's approach was sort of rationalistic and sort of not sufficiently appreciative of deeper, more fundamental political principle that preceded the Constitution and was in some sense, was sort of silently embodied by the Constitution.
Hamilton might have wanted to respond to that, but. Oh, yes.
Your talk has spurred me to try to ask myself the question, what changes in other aspects of the structure of the government might reduce the possibility for a tendency towards judicial activism? And one thing that came to mind is how hard it is to amend the Constitution, and just wondered what your thoughts were on that, if you thought a mistake was made in terms of the initial structure of the mechanism of doing that. If it were easier, what would the consequences be?
Well, I mean, you're right. If it were easier to amend the Constitution, there would have been less so-called judicial activism, because so much judicial activism was itself sort of an attempt to adapt the Constitution to changing times in the absence of a constitutional amendment. That said, if amending the Constitution were too easy, I mean, not to state the obvious, right, but if amending the Constitution were too easy, we'd have amendments that were fueled by more passion than reason, for worse, not for better. I don't know whether I think the upshot of all that is that it'd be better for us to change the amendment process so much as if we approach constitutional law in a way that recognizes that parts of the Bill of Rights especially they're broad enough to encompass new rights, not new rights sort of established by the court as a vanguard, but new rights that come up organically through experience. If that were to be, if that actually were how we did things, that might be the best possible way to achieve, the needs of a changing society.
Yeah, I thought I might have a clear way of asking what I was trying to ask before, which is that a second ago you admitted, I thought, some admiration for 19th century American lawyers who thought of themselves as finding the law and not making it by making their decisions. So, but that's what I want to ask you. Do you think that's the job of judges, to find the law? And I thought you were, in a way, saying that you wanted to say one sign of the legitimacy of a certain interpretation of the 14th Amendment, for example, is that you see that these various people come to the same point from these different points of time, and there's a general agreement about that. And nowadays we all do, in fact, recognize that this is the law. But I guess I would like some clarity, just an affirmation, which I think that you do think it is finding the law, and then how is it that you go about doing that? If it's not like the way in which common lawyers would do, which is that they could say, well, there's this tradition, there's men of reason who have used their reason to come to these principles, and maybe like Cicero mentioned it too, and he knew this was the case, and we also know this is the case. What is, if we reject that, and as you say, we don't have that tradition anymore, we don't tend to believe in something like that, how is it that we go about doing that?
Well, I think Obama said, "I reject your false choice."
Okay.
That the beginning of the process is one of finding the law, sort of genuinely trying to ascertain what the law is and how it applies, but always with the recognition that that last mile might require lawmaking. That the judicial task is to find the law as far as one can, but to be conscious of the fact that sometimes the law doesn't speak to the specific circumstances, and that last little bit of judgment by the court is not law finding, but rather law making. But that's not to say in all of that. That's not to say that therefore the entire task is one of law making.
Sure.
But rather it's law making at the margin after a genuine attempt at law finding.
This is maybe a partly historical question that I don't understand, but did they really think that? I think that's right, that laws are set down rules and they can't apply to every case. So what judgment means is applying that law to a particular case and seeing how it applies. But that means the human being has to be doing something to apply it in a given case. I'm just wondering if that last bit of discretion, or whatever you want to call it, or judgment, if that is still, you would still call it lawmaking, or I don't know if the word matters.
I would call it, maybe the word doesn't matter. I would call it lawmaking.
Oh.
And in some sense, the way that Hamilton phrased, what was it, Federalist 80, where he said they exercised neither force nor will, but merely judgment, I thought didn't do enough service to the task of judgment. Merely judgment. It's actually very, very, very difficult. And I guess the other place in the Federalist Papers that sort of speak to me as I'm thinking this through is Madison's line, and I'm sure half the people in this room will know exactly what it was and where it came from. But Madison's point that words aren't perfect. That when I wish I had written this down. That human language is of necessity imperfect. That it's impossible to understand at the outset the full meaning of the words we're using, and that they must be, what do you say, digested over time in legislative and judicial acts. And so in that sense, you have lawmaking by judges, by the president, by Congress alike, in the way that they take those terms and try to really ascertain how they do or ought to apply in novel circumstances.
That's in Federalist 37.
Thanks.
it's a cold day, and you've warmed us up and instructed us. So thanks so much.
Thank you. Thank you very much.